Good evening. We are going to start our lecture. Today, is our last lesson. It's our lesson 10. It's time flying. For this lesson, we'll cover chapter 7. Because in the last lesson, we have already covered chapter 10, legal aid, right? Now we are going to cover chapter 7, alternative dispute resolution, ADR. Because this chapter is quite short, so I think we don't need one lesson. So I think just one session something. We can finish this chapter, and then we'll do some final revision. I think all of you have the revision note, and also we'll go through the assignment. Please be reminded to submit your assignment before the deadline. Okay. Already recorded. So no, I think now the lesson is already recorded. Thank you very much, Michael. Now we will proceed to ADR. For ADR, I think I will show you a lot of website. So we have a lot of clips and also a lot of website relating to ADR. We will show you clips about more arbitration, and also I will show you a clip on mediation. So there are some clips provided by the judiciary. Okay? And also we'll show you the website of the Hong Kong Mediation Center, and also the Hong Kong International Arbitration Center. You can find a lot of very useful information from those websites. Right? So now we start our lecture. It's chapter 8. So chapter 8, right? So chapter 8, ADR. First of all, you can find we have altogether 6 formats of ADR, alternative dispute resolution. Alternative means alternative to litigation. Okay? In conventionally, when people have legal dispute, usually at the end of the day, if they cannot resolve the dispute by themselves, they will go to the court. Someone will take legal action, legal proceeding against the other one. So we have plaintiff and also a defendant. But as times go by, so we have invented so many format of alternative dispute resolution. All of them are quite useful. Of course, don't expect they will replace litigation. It's not possible. There are only some alternative, right? They can replace, they can replace litigation in some area, but don't think that they can replace all the litigation. And also, usually for ADR, there are civil dispute. For criminal offenses, of course, there must be court hearing. There must be trial. Okay. For alternative dispute resolution, usually they are only for civil dispute instead of any criminal offense. So altogether we have 6. The first one is arbitration, negotiation, mediation, conciliation, expert determination, and also mini trial. But of course, out of the 6, negotiation is very common sense. Negotiation, I think, strictly speaking, it should not be regarded as an ADR, because everyone, usually the party will have some kind of negotiation before they go to court. I think no one will take the case to the court without any, settlement or discussion. Okay, usually the party will have some kind of negotiation. Formally or strictly speaking, negotiation should not be regarded as a very serious format of ADR. Mini trial is also the same. Mini trial is only a more formal negotiation, a bigger scale of negotiation. Usually, the party will have a team of executives instead of just one person on each side. Each party will send a team of executives. For example, both party company, usually they will send a team of executives. For example, the accountant, the manager, etc. etc. Also to attend the mini trial. Again, I think very strictly speaking, it should not be regarded as ADL. But according to the website of AIAC or some other website, I think they are still included as ADL. Okay. So I think, and also for mediation and conciliation, usually even though they are two different names, but they are more or less the same. Okay. They are more or less the same. So we can say that so for ADL, the two major one is arbitration and also mediation. I will pay more effort. I will spend more energy to explain arbitration and also mediation. They are quite different in nature, and also they need more explanation. 仲裁 arbitration. I think some of you have heard of this term. So first of all, is arbitration similar to litigation? No, they are similar to some extent. They are similar. The similarity is that the decision is made by a third party who has power to impose his decision on the party. For both arbitration and litigation, we also have plaintiff and also defendant. Okay? These two formats of dispute resolution are quite similar because usually there's a third party. The third party is neutral. He has no interest, no dealing with the party, and then he will make a decision. The decision will be imposed on the party. So if you take the case to litigation, to arbitration, I don't think that you can refuse the outcome. Okay, if the arbitrator has made a ruling, usually the ruling is binding on the party. Okay, and also how can the party choose arbitration? How can they come to arbitration? Just like litigation. For litigation, of course, it's very easy. You just go to court, you submit the document as required by the court, and then you can start the litigation. But how about arbitration? For arbitration, one difference is that for arbitration, it must be consensual. Consensual means it must be agreed by both parties. Okay? You can never force someone to have arbitration unless he's willing to do so. Okay? But for litigation, you don't need any agreement. Okay? So if the other party does not like it, you can still sue him. You can still take the case to the court. But for arbitration, it's very different. So you have to get the consent. You have to get the agreement of the other party. So it's the reason why we call it consensual. So it may be either an agreement after a dispute has arisen. For example, we have a building contract. There's a dispute on the quality of the construction work. So the both parties agree to have arbitration to resolve the dispute. But most likely, more usual one is by an arbitration clause. 仲裁條款So later on we can show you a model arbitration clause. You are most welcome to use arbitration clause as suggested by the Hong Kong Arbitration Center. They always welcome you to use the model article clause. Model arbitration clause. Just add this clause. Just insert this clause in the agreement. For example, a construction agreement, building agreement, say an agency agreement, or partnership agreement. So you can use this clause in so many different types of agreement. So a simple one is the party agree to resolve any legal dispute arising from this contract through arbitration. It's a very simple one. But usually, so the model one, the model clause, will be much more sophisticated. So I can show you. This one is the website of the Hong Kong International Arbitration Center. Okay? So this one is the so you can choose a model clause. Okay. This one is a model arbitration clause. Model arbitration clause. Of course, it's much longer. So you can always go to the website of the Hong Kong International Arbitration Center. You can find several model clauses, you are most welcome to use them. Why? Because if you use those clauses, in case of any dispute, the arbitration will be heard in the Hong Kong International Arbitration Center. It means that they will have more business, they will have more income. It's the reason why they always want you to use this arbitration clause. You copy them, they will never sue you. don't be afraid. Don't worry. So no, they will never sue you. They always welcome you to use their say model arbitration clause. So don't underestimate the importance of the arbitration clause. Why? Because if there's already an arbitration clause in the contract, it will have a very important significance. Usually, it means that the party can never bring the case to the court. Why? Because first of all, we know that in contract law we have the concept of freedom of contract. In common law, usually the court will respect the freedom of the party. Will respect what they have agreed. Okay. So usually the court will not interfere with the contract, except some very special circumstances. For example, the contract is illegal, the contract is induced by deception, fraud, or undue influence, etc. So in general, the court will not interfere. For example, you sell the product at a certain price, the court will not say, oh, it's too low, so you have to raise the price. Okay? So usually the court will not interfere. So the agreement, for the contract between the party, the document is called agreement. The agreement may contain a clause which requires that where the party to a contract are bound by an arbitration agreement, no action can be brought in court before the determination by the arbitrator. The effect of the clause is that it will exclude, litigation in the court. So if you are a party to the contract, if the contract has an arbitration clause, whenever there's any dispute, the party cannot bring the case to the court. They can only use arbitration to resolve the dispute. So it's the effect of the arbitration clause. Unless you are very willing to use arbitration clause, don't include an arbitration clause in the contract. Okay, because if you do so, you'll be bound by this arbitration clause. You cannot go back to the court. You cannot take the case to the court. Of course, some students will ask, how come the arbitration clause can exclude the jurisdiction of the court? Because in Hong Kong, all the disputes are subject to the jurisdiction of the Hong Kong court. Okay? Of course, as we have mentioned before, so for civil cases, very different from criminal case. So for criminal case, say no defendant want to be prosecuted. Okay, so everyone does not want to be prosecuted. Okay, you don't have to discourage someone to be from being prosecuted because no one will want to be prosecuted. But in civil case, it is very different. Why? Because the court always want to discourage people from taking legal action. Okay? Because by doing so, the court has to spend a lot of time, and also is at the end of the day, it's the taxpayer money, it's the public resources. So if too many people take legal action, so it will be very disturbing, very annoying, and also it will be wasting a lot of money of the government. Okay? So the court always want to discourage civil litigation, especially something not too meaningful, something not so without any reasonable ground, etc. And also, the court will always like to do less. Okay, they don't want to handle so many cases, so they always welcome some other people can take up the job of the court. Okay, so arbitrator can play such a role. Arbitrator, so we can use an analogy. The court is like the public hospital. Okay, arbitrator, arbitration center is something like the private hospital. Okay, so they're self-financing. They charge a higher fee, but the party can enjoy better service, more convenient, more effective, and there are so many advantages of using arbitration. Okay, so it's the reason. So do you think the court welcome or do you think the court like or does not like arbitration? Like or dislike? Do you think the court like or dislike? Like or dislike? Yeah, very good. Everyone knows that the court like arbitration very much. Why? Because if more people go to arbitration center, what can the judge do? The judge can leave the office early. They can go home or they can go anywhere they like. So they can enjoy life. Okay. So of course they are not worried. The arbitrator will take the job and they will be unemployed. So for the judge, they have security of tenure. They have very good job security. They are not worried that they will be replaced, so they will lose the job. So it's not the worry. So they are just worried of too many cases. Okay. So it's the reason why they always like arbitration. They do not regard arbitrator as the competitor. Okay. So they like arbitration so much. They always welcome when people go to have arbitration. Because arbitration is self-financing. Self-financing means that the arbitration center does not receive any subsidy from the government. They can generate good enough. They can generate good enough income for the center. They don't need the subsidy from the government. So it's very different from legal aid. In theory, the court can always interfere. But of course, you know that the court is unwilling to interfere. Okay, and also in practice, the court will not interfere. If an action is brought, so in the court, the defendant may seek an order from the court to stay. To stay means to suspend. It's a legal term. Stay or proceeding means to suspend, to stop the proceeding. The reason is that the party should keep to the agreement. So if you don't want to use arbitration, don't include the arbitration clause in the contract. Okay? So if there's no arbitration clause, you can take the case to the court. But if there's an arbitration clause, usually you are not allowed to take the case to the court. And so we have two different types of arbitration agreement: international and also domestic. For international, it's between company in two different countries. For example, if there's a contract between a Japanese company and a German company, they may choose Hong Kong to be the venue of the arbitration. Because Hong Kong is neutral, we will not have any bias towards the Japanese company. We won't be a bias towards the German company. So we are supposed to be neutral. We can be relied upon by the two company in different countries. And also we have domestic arbitration. Domestic arbitration, it means the both parties are in Hong Kong. For if it's an international, if it's an international arbitration, the court has no jurisdiction to grant a stay. So the court proceeding must be stopped. Okay. So in domestic, even though the court has jurisdiction, but usually the court will grant the stay of proceeding. It means that for all the arbitration agreement, if the party have arbitration agreement, usually the court will not interfere. The court will not hear the case. Procedure, I think you don't need to know the details of the procedure. So the rules and procedure are governed. We have different sets of rules. The party have the freedom to choose whichever set of rule they like. They can use the international one. There's the International Chamber of Commerce (ICC), or they can use the procedure of the Hong Kong International Center (HKIAC), or they can use the procedure in the CITEC, China International Economic Trade and Arbitration Commission. Some people, some businessmen, they don't want the case to be heard in the court. They don't prefer the court hearing in China. So they prefer this one, CITEC. Judicial review. If the party, if the arbitrator has made a ruling, so he has made a award. Do you think the the defendant say no, do you think either party can appeal? Do you think the plaintiff or do you think the defendant can appeal to the court? So if a party is not satisfied with the arbitrator's award, can he appeal on any question of law arising out of an award? In the court case, in arbitration and also litigation, usually we have two major questions: question of law and also question of fact. Okay. For example, whether the quality of the material is up to the measurement, I think is a question of fact. But say what's the legal definition? For example, what's the legal definition of merchantability, fitness for purpose? It may be a question of law. For question of fact, usually the court will not interfere because I think the arbitrator is in a better position to determine the issue of fact. Okay? For a question of law, there may be appeal. The appeal is only confined to question of law, 法律嘅爭辯。Okay? If the appeal is on question of fact, usually the court will not intervene. But if the appeal is related to question of law, of course the court will interfere. But there are some restrictions. Either with consent of all parties. Okay? If the defendant wants to appeal, he has to get the consent of the plaintiff. Okay? So it means that if you lose a case, you have to get the consent of the party to win the case. Okay? And also you must get the leave. Leave is a legal term. It means permission. Okay? Later on, you go to Module 2, you will find this term. Leave, it does not mean holiday. So sometimes leave means holiday, for example, the annual leave, maternity leave. Okay? But in this context, it means permission. As usually for appeal, we have to get the leave of the court because the court does not want any case which has low reasonable ground to appeal because it will be wasting the cost time. The court must not grant leave unless it considers the determination of the question of law could substantially affect the rights of one or more of the party to the arbitration. It means that so there must be more reasonable ground, and also there will be possible impact on the interests of the party. And award may by the leave of the court be enforced in the same manner as a judgment or other. Of course, in Module 2 you will know more. If you're in Hong Kong, even though you can get a judgment, so you may not get the money, you still have to enforce the judgment. In Module 2, civil procedure, you will know more about enforcement of judgment. And now we would like to show you what arbitration look like. Many students will ask, so what does it look like? Please look at so arbitration. It look like a meeting. It look like a meeting. I can tell you. Okay, arbitration. It look like a meeting. So can you hear the voice of the kid? For arbitration, usually there's a panel of arbitrator. So the number of arbitrator is agreed by the party. So for example, it may be say one arbitrator, single arbitrator, or two arbitrator, or three arbitrator. And then we have for both sides, usually they will send a team of executive. So you see, they will send us a team of executive to attend the arbitration. So it's the panel arbitrator. These are the two different teams. Okay? So the plaintiff side or defendant side, usually they will send a team of experts like engineer, accountant, or say other people, architect, etc. And also for arbitration, mainly they are on business dispute, commercial dispute. The most usual one is say construction, engineering, shipping. Most of them in Hong Kong, most of the arbitration are related to say property. For example, construction, building material, etc., etc. Okay, so this is the most important type of arbitration case in Hong Kong. Okay. Also, we would like you to visit the Hong Kong Arbitration Center. This is the web page of the Hong Kong Arbitration Center. So you can find basically the arbitration, mediation, and also some other area. But the two major ones are arbitration and also mediation. You can find many arbitrators. They are also mediator. Okay. So this center, they do not only provide arbitration service, they also provide mediation service. Mediation, later on you will find that mediation is the difference is that mediation they will cover many other non-business cases. For example, divorce or estate management or succession. Arbitration mainly is on commercial dispute. Okay, so dispute between the employer and the contractor, etc., etc. Okay, so also you can find arbitrator. So you may want to know what the arbitrator look like. There's a database. There's a database. You can always find people. You can use different criteria to search those people. We can just choose Hong Kong. We can just choose arbitrator in Hong Kong. You can find those gentlemen. Most of them are gentlemen. You cannot find too many female. Okay? For example, so you can find the background. Most of them are, some of them are lawyer. But it's not necessary for arbitrator to be a lawyer. But most of them are lawyer. And also they have some other expertise. For example, this gentleman. You can find the CV. You can find the CV. You can find lots of details about that gentleman. Okay. So usually they are professional. Even though they are a lawyer. Okay. But there may be some people who are not lawyer, like architect, engineer, or surveyor. But usually they have some legal background. For example, they have a LB or LLM. So they are quite familiar with legal procedure or law, etc., etc. Okay. You can find lots of details about the CV, the expertise, skill, language, jurisdiction, admission, etc. Of course, you can find the contact very easily. You can also find the cost and fee. So it's quite expensive, I can tell you. The hourly rate arbitration. So hourly rate, I think is it's quite expensive. So you may have a look. Right? It means the arbitration center will charge fees, and also the arbitrator usually they are professional. You have to pay for those people. So it will be more expensive. Sometimes it may be more expensive than court hearing because so you don't have to pay for the judge. You don't have to pay too much money to the government for the court action. But sometimes litigation is very we have a lot of procedure before the trial. It takes a very long time for the case to be set down on trial. So it's the reason why so many people prefer arbitration. For the proponents of arbitration, they argue that benefit of arbitration include first of all flexibility. Flexibility means that the party can simply agree on virtually everything. They can agree on the procedure, they can agree on the venue, they can agree on the time, they can agree on the place, they can agree on the panel of arbitrator. They can agree on so many things, eh? But for legal action, so you don't have any choice, eh? Nearly everything is decided by the court, eh? Neutrality, I think is no difference from a litigation because judge is also supposed to be neutral. Parties are free to choose a neutral venue. Venue is neutral. For example, as I have mentioned before, if there's a contract between a Japanese company and a German company, if the case is to be heard in the Japanese in the court of Japan, of course, a German company so may not feel so good. If the case is heard in Germany, so the Japanese will not feel so good, okay? So they will prefer to have a neutral venue like Hong Kong or Singapore or Sweden. They're supposed to be neutral, so it may be more comfortable to both parties. So parties are free to choose a neutral venue for the arbitration when drafting arbitration clauses. So it's especially true for some contract involving company in two different countries. A party may also appoint independent arbitrator to form a neutral tribunal. So it means that they can choose who are going to be the arbitrator. And also a very big attraction is confidentiality. Because all of us know for court hearing is open to the public. And also the judgment is open to the public. Okay? So the judgment may have a lot of say commercial secret. For example, the price of good, the salary of the employee, the commission of the employee. For example, I read a case relating to say the income of those people in the health center. So if you're a client of a health center, you will feel so surprised. For those people, they earn so much money. Sometimes it may be embarrassing to the company if the public know the profit, know the salary of the staff. So because it must be disclosed to the public. But for arbitration proceeding are held in private and not open to public. Many people like it. Many businessmen like it. They don't want the public to know too much about the business or the company. And also finality and binding. Awards are usually final and not subject to review on the merit. So prolonged appeal through the court is avoided. Because we have to know for litigation, usually the party who lose the case can appeal to the court of appeal and then court of final appeal. So you have to wait for a very long time before the case is concluded. Okay. But for arbitration, usually it's one-off. Whether you may win or whether you may lose, but usually there is no appeal, right? No further appeal. And also the other attraction is the expertise of the arbitrator. As I have mentioned before, arbitrator usually they are professional in that particular field. For example, this dispute is about the quality of the building material. So usually they will ask a surveyor, a quantity surveyor, architect to be the arbitrator. The arbitrator is very familiar with those issues. He can understand the dispute much more easily than a judge. Okay? So party may select and agree on a person with relevant expertise. For example, an engineer, architect, a surveyor, and also experience to hear a dispute. So they can save a lot of time. Okay? So the arbitrator can understand the case much more quickly than a judge. So the party can save a lot of time if they use arbitration. But on the other hand, so don't think that's one-sided. So arbitration, they also have some disadvantage. On the other hand, as arbitration proceedings are generally not open to the public, decisions are inconsistent. Why the decisions are inconsistent? Because the arbitrator does not know the decision made by other arbitrator. For a judge, he can refer to the judgment, to the decision made by other judges. So we have the doctrine of precedent. So the party, they can refer to cases in the past, like a case in 1980, a case in 1990, a case in 1994. But for arbitration, you are not allowed to do so. You cannot refer to the decision made by another arbitrator because they are supposed to be confidential, right? So if the decisions are inconsistent, so they are difficult to predict. So it means that you find it very difficult to predict the decision to be made by the arbitrator. So these are the relative advantage and also disadvantage for arbitration. But still, most people like arbitration, especially for business dispute. Okay, some dispute relating to construction, engineering. Usually, the party would like to have would prefer arbitration. The other one is called negotiation. So the party are free to decide the dispute by negotiation. There's no assistance by any third party. It means that the both party to the dispute they just have a face-to-face meeting, and so they can negotiate on how to resolve the dispute. And now we go to conciliation. Conciliation is very similar to mediation. So now there are not so many people use the term conciliation. Most people will use the term mediation instead of conciliation. So they are very similar. Okay. So it involves the party coming together in the presence of an independent third party. So similarity with arbitration is that there's an independent third party. For arbitration is the arbitrator. For mediation is the mediator. For conciliation is the conciliator. His role is to help the party to reach agreement by giving advice, offering suggestion, and persuasion. Please note that for conciliation and also mediation, the mediator or the conciliator, he will not make any binding decision. Okay? It's very different from arbitration. His job is only to persuade, to advise, to help the party to reach agreement. Sometimes we can say that his role is like a estate agent. Okay, for example, if someone want to buy a flat, so he will use the estate agent. The estate agent will try his very best to encourage, to help the party to reach agreement. Okay, so conciliation or mediation is more or less the same. So conciliation is very similar to mediation, but conciliation is the term used in respect of a dispute in employment and in which the labor department assists the party to settle. So it's the reason why we still use the term conciliation. Other than say conciliation by the labor department. So I think nowadays not so many people use the term conciliation. Most people use the term mediation. Mediation is very similar to conciliation, as the aim is also to enable party to settle their differences by agreement. But there may be a very minor difference. Mediator will take a more active role in helping the party to reach agreement. But the difference with conciliation may be blurred in practice. It means that it's not easy to point out the difference between mediation and conciliation. But usually, as we have mentioned before, usually nowadays not so many people will use the term conciliation. Most people will use the term mediation. Okay? Mediation is usually agreed after a dispute has occurred. Mediation clause is not too common, except government contract. Okay? Some government contract will have a mediation clause, but for many mediation cases, they are usually agreed after a dispute has occurred. It means that there's no agreement, so before the dispute. Okay? For example, if there's a water leakage case, the party would prefer to use mediation to resolve the dispute. So it's only used after the dispute has already occurred. A typical example of dispute like estate management, family, construction, or other whereas small company. So the dispute is between small company. But for arbitration, the dispute usually is between a very big company. Now we can see what mediation look like. First of all, okay. So I would like to show you a clip. So you can see if you go to the website of the judiciary, you can find several clips relating to mediation. Because the court welcome mediation, not only welcome mediation. In fact, the court always encourage the party or even press the party to use mediation. We can find a clip. So this one is very funny. The conversation is in Cantonese. Very sorry. The conversation between the parties is in Cantonese. But there's some English subtitle. I will explain the case to you from time to time. This one is probate succession dispute so dispute in succession 嗰啲繼承遺產嗰啲This one is a business dispute So these are the three typical cases of three typical types of mediation case. So this one, estate management, succession, probate, and also business. The court always discourage people from using litigation to resolve the dispute. So it's a dispute in succession. The father has passed away. So now there's a dispute between the elder sister and the younger brother. The party cannot resolve the dispute. Because if the party try to resolve the dispute by themselves, sometimes they will use some inappropriate language, and both party will be either party or both party will be very sensational. They will be very emotional. They won't be so rational. So they need the help of a third party. So the young brother goes to see a doctor, to see a solicitor. So the lawyer tell him he should use mediation, and there will be no lawsuit. Okay. So I don't know why the lawyer every time when I see this clip, I don't know why the lawyer is so happy. If there's no lawsuit, there won't be any business, and also there won't be any income for the lawyer. Okay? So why the lawyer is still so happy? Okay? Maybe the lawyer is going to retire. So maybe the lawyer said, I'm going to retire, I will close down my law firm. Okay? In fact, the judiciary, the court has prepared a lot of information session to the litigant. So there's I think there's an officer to explain the use of mediation, and also they will provide a lot of information to those people so that they can choose a mediator. People that the court will not recommend any mediator. They will only show a list of mediator to the to those litigants. Okay, they can choose either one they like. They can choose anyone they like. But of course, they will look at the background of the mediator. Usually, they will prefer a mediator with legal background. It means that so in practice, many mediator are junior counsel. Because usually, I think most solicitor will prefer to use a junior counsel to be mediator. Okay. Of course, some lawyers are also mediator. As we have seen before, in the website of the Law Society, you can also find a list of mediator. It means that many solicitors are also mediator. But as told by some of my friends, they say that if you want to be a mediator, you cannot be a good litigator. Okay? So sometimes they are in conflict. Because for good litigator, good litigation lawyer, usually they cannot be a good mediator because they have very different mentality. Okay? So as a litigation lawyer, you have to be very critical, very aggressive. But if you are a mediator, you have to be very patient, etc., etc. So it's the reason why a good litigation lawyer usually he cannot be a good mediator. It's also true. So for mediator, you find the background are very different. Later I will show you the list of mediator in the Hong Kong Mediation Center. You see the background is very different. This is what mediation look like. So in fact, it's very informal when compared with say arbitration. I think mediation is more informal. It can be a very small room anywhere. So sometimes it's in the chamber of the junior counsel. Sometimes so you can also book a room in the some mediation center to conduct the mediation. Of course, in practice, the mediator will suggest some solution. Of course, it's up to the party to choose whether to accept the proposal by the mediator. Okay. So according to statistics, I think only 20% of the mediation case that they can be resolved by mediation. I mean that many people, they refuse to accept the outcome of the suggestion of the mediator, right? They refuse to agree on the settlement. I mean that they still want to go to the court to resolve the dispute because sometimes it's not easy. If they have reached an agreement, they will sign a settlement agreement. The agreement is binding on the party. So if the if the party have already signed on the settlement agreement, usually they cannot change the mind. That's also the reason why someone with legal background will be preferred because he also have to prepare a detailed settlement agreement. It may involve some legal knowledge or legal expertise before he can prepare the written agreement. Probate, it means the procedure in succession case. This is a term. So it's the name of a subject. It's the name of a subject you study if you remain here in the second year. In DLS, a Diploma of Legal Study, there's a module called Succession and Probate. Probate mainly is the procedure. It's the procedure for succession case. Also, it's very funny. So now how come the relationship is so good after a probate, after I say a mediation case? You just look at this picture. What can you think of? Can you think of any? Can you think of mediation? You just look at this table, this picture. I think it looked like they want to get married. I think for this picture. So if you just look at this picture, so there's an information session. Because the court always encourage people to have mediation. So it looked like that they want to get married. They just make an inquiry on the procedure of getting married. They don't like people. They don't look like people in dispute. Okay. It's also not open to the public, so it's confidential, so it won't be disclosed to the public. It's also informal, right? And also, one of the attraction of mediation is that they can talk face to face. And also, of course, it's in Cantonese, so they can save a lot of trouble. Because in litigation, a lot of communication must be in writing, and also So usually the party cannot have a direct dialogue. So they have to say pass a message through the lawyer. The lawyer will take instruction and will prepare a draft letter, and so the client will review the letter to approve the letter, and then they send out the letter to the lawyer of the other side. It is something quite expensive, but in mediation, the party can have direct dialogue with the other one, so that they can save the energy and also they can save the legal costs. Usually the mediator must be very patient, okay? Because for the party, they are only laymen, they do not know too much about law. Sometimes they may not know, they have low ground in law. So the mediator, he has to be very skillful in explaining some legal concept to the party, and very patient in listening to the complaint, and also very tactful in proposing some solution to the party. It's very funny. So no, they get along so well after the mediation. In practice, I think it's something quite unlikely. Usually for party in dispute, even though they agree to resolve the dispute by mediation, usually they are under the pressure. Because if you do not agree on how to resolve the dispute, you do not accept the proposal for settlement, you have to spend a lot of time, a lot of energy, a lot of money in litigation. So sometimes the party, the plaintiff, he will be forced to accept the settlement, maybe just several $1,000s, so that he can resolve the dispute by just accepting a small sum of money. It's better than nothing. Because if you keep on the litigation, you keep on suing the other party, you have to pay a lot of legal costs, you have to spend a lot of energy, you have to wait for a very long time before the case can be heard in the court. So this one is very funny. I think you can learn more, you can understand more. Okay. So okay, for mediation, so we know that government and also the judiciary are very enthusiastic in promoting mediation. Okay, because for mediation, if more people use mediation, less people will go to the court. It's really a big problem for the court, as nowadays people have better legal knowledge, so they know the legal interests, and of course we have more law students. So many people studying law, so they know the legal position and they want to protect their legal interests. Right? So this is also the reason why so many people like to use legal action to resolve the legal dispute. Of course, the court cannot handle so many cases. This is the reason why they always want to encourage more people to use ADR, especially mediation. So there are various ways in which the process of mediation may begin. Either it may be initiated by the party, or there's a contractual obligation. Maybe sometimes especially in some government contract, construction contract, there's a mediation clause. If there's a mediation clause, when they have this dispute, they have to use mediation to resolve the dispute. Right? Obviously, court related. Sometimes the party are suggested by the court at any time, any point during the proceeding. Because sometimes the court think that the dispute is very trivial. So it's not a very big business, and for example, it only involve very small sum of money. So the court think that it will be more preferable for the party to use mediation to resolve the dispute. So and also sometimes there's a court-induced ADR. I think the court has already amended the procedure, so that from time to time the party have to use mediation to resolve the dispute before the case can be heard in the court. So it's an incentive to the party to negotiate settlement if necessary with the aid of a mediator. The court always encourage settlement. In the past, settlement are only made by the lawyer, but people that are lawyers usually they are very litigation minded. For litigation lawyer, so they may not be too patient. They may not be so tactful in reaching settlement. Okay? Sometimes they are very confrontational, so it makes settlement more difficult. So I think for settlement, a mediator may be more tactful, more experienced, more skillful in helping the party to settle the dispute. So the new mediation ordinance provide a regulatory framework in respect of certain aspects of the conduct of mediation. The ordinance will came into operation on 1st of January 2013. As a summary, so we can find the advantages of mediation for the proponent. They argue that mediation may support a more constructive and less confrontational environment between the party. Because in litigation, so the party have to instruct the lawyer to pass the message to the lawyer of the other party. Okay? Sometimes the wording used in the letter may be very sensitive or confrontational. Sometimes it will offend the other party very easily. Especially for lawyers, they use a lot of legal jargon. So by doing so, usually the other party, after he has read the letter from the other side, he may feel more angry. He may be offended, and so the environment is not so good. So the party will find it difficult to settle. If the environment is so confrontational. The party may better control the outcome. Because for mediation, no one can impose anything on the party. No one can force you to accept any outcome. But litigation is different. For litigation, if you lose the case, so for example, if the court order the defendant to pay $1 million as compensation to the plaintiff. So it's something imposed by the court. Okay? But in mediation, the party can always agree, can always negotiate. So and also if the proposal is unacceptable, the party can always refuse the proposal. Right? So it may promote communication between the party because the party will have the meeting face to face. So they can tell the other party what they want. They can tell the other party their consideration. There's no need to use the lawyer to pass the message. So the next one is maybe more efficient and cost effective. So for mediation, by experience, so maybe a 5-day litigation. So if the party use mediation, so they can use just 1 day. So for the mediation, they can resolve the dispute by just 1 day instead of a 5-day litigation. Because for litigation, everything is so formal. All the procedure are very formal. You have to follow all the rules and procedure laid down by the court. Okay? So it's very time consuming, and also all the time the lawyer will charge you. You retain a lawyer to represent you in the court. He will charge you for all the time, every minute he serves you. So it's something quite expensive. Process is confidential. Confidential means it's not open to the public. So of course it can avoid so a lot of embarrassment. So it will be much better for many people. It's not an imposed settlement or judgment. No one can impose anything on the party. It may allow for settlement. That's more flexible and more practical than a legal remedy. The court is empowered. So when you study contract law, you know the possible remedy. Remedy means the award of the court 司法報告so means what the court can award to the party of the litigation usually is money compensation is also called damages and also injunction, specific performance, rescission but for mediation there may be different no ways for settlement so no you can ask for apology, you can ask for so many things so the settlement may be in different format so there will be more flexibility now please go to page 136 to do activity 1 please go to the manual page 136 and we do activity 1 Okay, so please do activity 1 in activity 1 there's a dispute between two parties so this dispute is very similar to the previous one to the one we see in the clips right so there's the case is about water leakage leaking water leakage right so we have Mr. Wang he was living on the 5th floor. Okay, so Mr. Lee was living on the 4th floor. There was leaking water. It caused damage to Lee's flat, which will cost him $5,000 to repair. Lee want to sue Wang in the land tribunal. He's unwilling to compromise because he said it's Wang's fault. Wang denied his to blame and has refused to discuss the matter with Lee. So your task is you have to determine whether it's a case for litigation, mediation, or both. Give reason for your answer. Okay. So the second question: will your answer be different if Lee does not want to jeopardize his relationship with Wang? Please write down your answer. Okay. So I give you 10 minutes to do this activity. Okay, so please use what you have learned in answering this question. Try to see whether it's a case for litigation or mediation. Okay, so we will resume the lecture. Okay, I think for this question, of course, on the face of it, it seems to be a quite difficult question. 比如 It's only a very small. I think it only involve a very small sum of money. It's only 5,000. So it's a very small sum of money. It can maybe is subject to the exclusive jurisdiction of the land tribunal. So they cannot go to the small claim tribunal. But the point is that even 5,000 is a very small sum of money for a hearing in the tribunal. Of course, it's much better if they can go to have mediation. But one of the prerequisites, one of the requirement of mediation is that you have to get the agreement of the other side. Okay, so it means that both parties must agree to have mediation. You can never force anyone to have mediation. So nothing for those gentlemen. I think they cannot solve the problem so easily because they simply say, I think Wang simply refused to discuss the matter with Li. So if Li invite Wang to have a mediation, I think usually Wang will just simply refuse. Okay? So it means that in the meantime, it won't be possible to have mediation between the two gentlemen. Okay? So I think I will just look at the reply or in the chat room. Michael said, initially it will be litigation as Wang refused to discuss with Li. Li cannot force Wang to mediation to do mediation. As both parties agreement in this case go to court. I think the court will tell them to go mediation and don't waste any time. Okay. Very good. I think it's a very practical suggestion. What Michael have said is something very practical. Because if you just invite, say, the party to have mediation, usually at the very beginning, so it won't be possible for Li to say ask Wang to have mediation. I think most likely Wang will simply refuse. Because Wang simply refused to discuss the matter with Li. So you cannot even communicate with him. Okay, so no, you will knock on the door of his friend. I think he will just he will be very angry and say there will be a lot of dispute between the two parties. So I think inviting him to have mediation at the very beginning is something quite difficult. So a very practical way is to take the case to court. The court usually will ask the party to have mediation. So if the court asks the party to have mediation, I think it will be much easier. So usually a citizen will obey the instruction of the court. So he will follow the instruction of the court and go to have mediation. And of course, in practice, it will be much better to use mediation to resolve the dispute. Maybe at the end of the day, Wang agreed to pay $2,000 or $3,000 to Li. Okay, so of course, Wang will not pay the full amount. That's the 5,000. So they have to compromise. So from the angle Li, so at least he can get some money from Wang. It will be better than nothing. Okay, and also Wang can just pay $2,000 and then he can resolve the dispute. So will answer be different. If Li does not want to jeopardize his relationship with Wang, if he does not want to jeopardize his relationship with Wang, I think, I think there's nothing he can do. So if Li does not want to sue Wang, and also if Wang does not say agree to have mediation with Li, I think so if both options are not so practical, so I think Li simply cannot have nothing to do. Because if you sue someone in the court, it will also offend someone. So usually, so if Li take the action to the court against Wang, usually Wang, after he has received the I think the court document, usually he will feel quite offended. I think most people will feel offended when they are being sued by someone. Now we may go to the website of a center called Hong Kong Mediation Center. I think they have the English version. So we go to the English version. Right? So it's they have a lot of services. So it's mainly mediation service. You can see the mediation clause. So it's a mediation clause. So you can insert this mediation clause in any agreement with the other party. For example, in an employment agreement, agency agreement, or etc. etc. Okay. So you are most welcome to use this standard mediation clause. Okay. Usually, the party will be submitted. Any dispute arising from or in connection with this contract shall be submitted to Hong Kong Mediation Center for mediation, which shall be conducted in accordance with the center mediation rules in effect at the time of the mediation. So it means that if you use this clause, so the center will have more business when the party have dispute, and also they will have more income. So it's the stage. This is the procedure for mediation. This one is the charge. So if you just consult, you just make consultation of mediation is free of charge. Admin fee for the application of mediation service is $2,000. Mediator also is something quite different for different mediator, right? So the service charge per hour range from 1,000 to 3,000. Right? But of course, the practical difficulty is that so even though you can be mediator quite easily, but to get business is not easy. Some people they attend the training course and become accredited mediator, but the point is that it's not easy to get business. Also, you can find the mediator. Those people that are called accredited mediator. Accredited means that they're accredited by this center. You can find the panel of mediator. Okay. So not all of them are professional. Some of them are lawyer. Okay. For example, Mr. Lee Wyman. Siu Wing-Yi, he's also, I think he was a council member of Law Society. Some of them are all a lawyer. For example, Chen Bingwen, Liang Tianxing. Right? Some of them are quite seniors or experienced solicitor. But you can also find the fact that those people, they come from different walks of life. For example, some of them are social worker. Pastoral caregiver 傳道人啦。This one is a radiation therapist. A nurse or teacher or even housewife paralegal law clerk some of them some law clerk are also mediator. Marketing, okay. So you find the background is quite different from arbitrator. But for arbitrator, usually they are professional or lawyer or architect, surveyor or something. But for a mediator, I think the background will more, I think maybe more extensive. For example, investment compliance officer Captain Cool 係咪機師咁樣？係機空少嘅所謂係clergy 牧師housing manager so and sometimes you can find housewife or retiree they can also be mediator. Okay, please also do the other activity. Please go to page 139. Go to the website of Hong Kong IAC and examine a sample arbitration. So it's something we have done before. So you may now go back to the website of the HKIAC. You can find this one. This is the model clauses. This one. So you can do it by yourself. This one is a model arbitration clause, right? Also, arbitration clause. Also, we have the governing law. The law of this arbitration clause shall be Hong Kong law. Seat of arbitration shall be seat means with the venue. So it should be Hong Kong or some other place. A number of arbitrators shall be 1 or 3. Okay? You can choose either one. Usually it's odd number. 1 or 3. Arbitration proceedings shall be conducted in whatsoever language. Usually it's in English. Okay, these are the model clauses for arbitration. Okay, then we go to the next one. This one is called expert determination. Okay, 專家裁判。So the dispute is to be determined by an expert who shall not act as arbitrator, but whose decision shall be final and binding. Please note that expert determination is different from arbitrator. But basically, he will make a decision. It's enforced as a contractual term. Usually, why we have expert determination is because there's already a clause in the contract. It's already a contractual term. So it's something provided in the contract. So it's not a judgment. It's not an arbitral so I can show you a very typical example. The most typical example is a tenancy agreement. Okay? In a tenancy agreement, sometime, for example, the duration of the tenancy is 3 years, but the tenant would like to have an option to renew the tenancy, for example, for a further 3 years. Because when he signed the tenancy agreement, he would not know the prevailing market rental. For example, he signed the so you can use a very simple example. Okay, for example, so in the year of 2017, the parties signed a tenancy agreement for 3 years. There's an option clause. Many tenancy agreements, they have an option clause. The reason why we have the option clause because especially for some commercial tenancy, okay, for example, a shop, usually the tenant has spent a lot of money to decorate the shop. So if he has to move after 3 years, so of course he will he will lose a lot of money because the decoration is still very new, and so if the landlord increase the rental by a very big percentage, the tenant will find it unacceptable and he has to move out. He will lose a lot of money. So it's the reason the tenant usually he will demand an option, 續租權. Okay, I mean that in the year 2020, I can choose whether to renew the tenancy for a further 3 years or not to exercise the option, right? But of course, what is the rental? Of course, the party will agree that the tenant will agree to pay the prevailing market rental. Prevailing market rental means the market rental in the year of 2020. Okay, but what is the exact figure? the exact figure will be decided by the expert. Okay, so it's not say I think it's not agreement between the party. So it's not negotiation between the party. In fact, it's something. The figure is to be determined by an expert. Usually, it's a surveyor. The surveyor will determine the prevailing market rental. He will do some research on the comparable rental of a shop nearby with a similar size or similar location, etc., etc. He will do a lot of study and find out the answer. For example, if his determination is that the prevailing market rental should be 20,000. So if the tenant want to exercise the option, he has to pay 20,000 per month to the landlord. It's because it's the prevailing market rental. Of course, in some other cases like valuation of share or asset, so from time to time the job will be done by the expert. There may be a different expert for different job. For example, for rental matter or tenancy matter, usually the job will be done by surveyor. But for share or for other asset, there may be some people call valuer, 估值師, right? So now they are doing the job of valuation. We can for say for expert determination, we can summarize the role of the expert. First of all, it's a form of binding adjudication, because it means that the decision made by the expert will be binding on the party. Okay? If the expert say determine the market rental to be 20,000, so the party, the tenant, has to pay 20,000 if he's going to exercise the option to renew the tenancy. Number two, the power and duty derived from a contract between the party appointing the expert. So it's based on the contract. That's the tenancy agreement between the landlord and the tenant. And also it's not arbitration within the meaning of the arbitration ordinance. So the expert, he will not make other decisions. He only make a decision on the prevailing market rental, but nothing else. Right? And also there's no need for dispute to exist. Sometimes the party will prefer the expert determination instead of negotiation between the two parties. The expert decide what to do in all the circumstances. He does not have to consult the party. He has to do the research. He has to do the study by himself. Also, the process is inquisitorial. Inquisitorial means that it's not confrontational. It's not adversarial. Okay. So we know that in litigation, usually it's adversarial, just like a debate. But in this expert determination is inquisitorial. It means that the expert he will do the study by himself. The expert make his or her own investigation and is not bound by evidence presented by the party. There's no need for the party to give him any a reference or evidence or any figure. The expert simply will do all the investigation by himself. Number 7, the expert owe a duty to both parties to act with reasonable care and skill, and so may be liable in negligence. So if he's negligent in the job, so he may be sued by either party. So may appeal to court from the decision of the expert can be prohibited by the party. Sometimes the party would like to have a final determination. They don't like to have any further appeal. So the agreement may prohibit the party from taking the case to court or any further appeal. The last one is mini trial. As I have mentioned before, so mini trial in fact is not a very formal ADR. Okay, so strictly speaking, it cannot be regarded as an ADR. The dispute is to refer to a panel of senior executives from both sides to hear argument. The procedure is adversarial approach, but the outcome is negotiated between the two parties. So in fact, it may be regarded as a more formal way of negotiation. Negotiation sometimes is only between two persons, but for mini trial, it's something more formal. Each side will send a team of executives to attend the miniature. So in order to understand the difference between the litigation and so the ADR, you can refer to this table. So many students do not quite understand the similarity and also difference between litigation and arbitration. So you can look at this table. For similarity, both litigation and arbitration, so they involve binding decision made by a third party. So in litigation, the decision is made by the judge. Okay? So in arbitration, the decision is made by the arbitrator. Okay? So don't think that the arbitrator is only making suggestion. Right? He's not only making suggestion. He's not a mediator. He will make a binding decision. Okay? For example, if the plaintiff wins, the defendant may be ordered by the arbitrator to pay $10 million to the plaintiff. Okay? So the defendant has to pay the money. Okay? Because it's binding on the defendant. Don't think that the defendant can refuse to accept the outcome of the arbitrator. Just like a defendant cannot refuse to accept the award made by the judge. Right? Because it will be binding on the party. But the difference is that for litigation, he has very formal procedure. So you have to comply with a lot of rules and procedure laid down by the court. Also, there's no choice or very limited choice on venue, day, etc. Also, the money is subsidized by the government. The party only pay a very small sum of fee to the court. Okay? It cannot cover the cost of the court. So it's the reason why the court need a lot of money from the government. Okay? Because the salary for the judge and also many personnel, they are very high. Right? Even for the junior judge, so the monthly salary is more than 100,000 per month. Right? And also a lot of gratuity, retirement benefit, etc., etc. Right? So the cost is very substantial. So the party cannot cover the cost by the court. So the court needs a lot of subsidy by the government. Right? But for arbitration, it's informal. So there are a lot of more informal procedure. So they can choose the procedure, they can choose the arbitrator, they can choose the venue, day, time, etc., etc. Also, it's self-finance. So the cost will be borne by the party. For the party, they have to pay for the arbitrator and also the arbitration center. But because even though the charge is high, but because they can save a lot of time, so they can also save a lot of money. For arbitration and also mediation or conciliation, so both of them are ADR, but they are very different in nature. The similarity is that they are quite informal. Mediation may be even more informal when compared with arbitration. Mediation may be even more informal because usually the party can say whatsoever they like. They can do whatsoever they like. Okay? So when compared with arbitration, mediation, we can say that mediation is even more informal. Okay? But the difference is that for arbitration, the decision of the arbitrator is binding on the party. But for mediation, there's no decision made by the conciliator or mediator. So we call mediation to be an assisted negotiation. It's only negotiation between the party, but there's a third party. There's a neutral person who assists, who has been undergone the training, who has been trained to help the party to reach agreement. So we can say that it's an assisted negotiation. Sometimes you can say that the mediator, he played the role of an agent. So agent, of course, he will help the party to reach an agreement. So you may refer to those websites. This one is the Hong Kong International Arbitration Center, HKIAC. This one is the Mediation Center. of Hong Kong. This one is judiciary. You can find collectively we call it civil justice reform. So mediation is part of the civil justice reform. So the court always try to say simplify the procedure to make litigation more efficient. So have a better say effectiveness and efficiency. At YouTube also you can find a lot of clips on arbitration and also mediation. Please do filling in the blank. So before we proceed to the final version, or so it's a very short summary of this chapter. Okay, so these are the 6 formats of alternative dispute resolution. So the first one is negotiation, and then mediation, conciliation, expert determination, mini trial, and also arbitration. Which two are most important out of the 6 formats? Which two? Which two are most important? So we spend most of the time on 2 of them. Which two? Out of the 6, which two are more important? So many are typing. It takes us a long time to type. Okay, it should be mediation and also arbitration. The 2 most important and most popular ones are arbitration and also mediation. So many people use them. Every year, so many people use arbitration and mediation to resolve the dispute. But for arbitration, it's usually on commercial dispute. Usually, it involves a very big sum of money. For mediation, it may be commercial or non-commercial. Most of them are non-commercial. For example, divorce, say estate management, or say probate. So it's very common in Hong Kong for those disputes. I think mediation is quite effective. Because the people sometimes they don't have any document or evidence, so mediation may be more appropriate. So it's also one of the possible career for lawyer and also for non-lawyer. So some people they wanted to be lawyer when they were very young, but they lose the chance, they miss the opportunity, so they take up the job of mediator. Okay, even though they cannot be lawyer, they can still be a mediator. So many people would be quite happy if they can handle some mediation job. So two types of arbitration agreement. The first one is international. The second one is domestic. True and false. Number one, the party to arbitration can choose to accept the decision made by the arbitrator. True and false. Number one. So very good. It should be false. Because the decision made by the arbitrator will be binding on the party. Just like the verdict made by the judge. Okay. So decision of mediator is binding on the party. Number two. True or false? Now again, number two is false, because the mediator, he will not make any decision. The mediator, he will only make proposals, suggestion to the party. He will not make any decision. One of the biggest advantages of arbitration over litigation is flexibility. Number three. True or false? Number three is true. It's the biggest advantage because the party can always agree on so many things. Okay. Number four, the court does not like mediation. Like or dislike? It should be false. The court like it very much. The court like mediation very much. So the court always encourage people to use mediation. In the past, mediation was voluntary. It was not so successful. The court had taken a very big initiative to promote mediation. Number five, the party who loses in arbitration can never appeal to the court. True or false? It's also false. Because under some situation, under some circumstances, he can appeal. But usually the appeal is confined to dispute in law instead of dispute in fact. So either he can get the consent of the other party or he can get the leave of the court. So it means that not everyone can appeal. Only some people who can satisfy the requirement can appeal. Okay, now I think it's the end of this module, the last module. So it's the end of this topic. Now we go to assignment first. I think assignment is more important. First of all, I think I have already sent you a sample answer for part A. So part A is about a case Wang Chunying. So you have to answer those questions. Several years before, I've used a case of Markov fight. Markov fight is a quite famous criminal law case. It's a case about manslaughter, murder. Okay. You have to answer several questions. The first one is general area of law involved in the case. Don't try to summarize the fact. Many students just write down the fact. Okay, the case is about so and so on a certain day, what happened, etc. It's not what I want. You have to use the format of the catchword in the headlock. I think so. In chapter 4, we have mentioned the concept of headlock. Headlock is the summary. Usually in the headlock, there's a item called catchword. Catchword, it means the some of the keywords, of the case. So when you look at these keywords, you will know what roughly the case is about. For example, criminal law, murder, criminal appeal, manslaughter, intent to kill or do grievous bodily harm, or criminal procedure, sentencing. So by reading these words, you will have a rough idea of what this case is about. Why I want you to answer in this way? Because this one is very useful. Because in all the headlock of judgment, usually they will have very say that we have these keywords so as to help the barrister to know what this case is roughly about. And also the barrister can choose whether to read the full case or not. Because he has to decide whether the case is relevant to his practice. Issue is a point of dispute. Issue is a point of dispute. Usually it is in a question form. It's in a question form. For example, so in the case of Donald Hill and Stevenson, the issue was whether the manufacturer owed duty of care to the end consumer. Okay. So it's the issue. Don't repeat the facts of the case. Don't just copy some paragraph in the judgment in the answer. Okay. And also outcome. For outcome, again, no need to explain the reason of the outcome. Okay. Just tell me the outcome. Just tell me the outcome. Outcome is the party, especially the defendant in the criminal case, his most concerned with the outcome. Okay. So in appeal, the outcome is whether the appeal is allowed or dismissed. So in this case, the court allowed the appeal against the Court of Appeals judgment substituting a conviction for unlawful act, manslaughter in place of the murder conviction. So he was convicted of murder in the lower court, and now he appealed. The appeal was allowed. So his conviction is now manslaughter instead of murder. Okay. So it's the outcome of the case. No need to explain the reason for the outcome. No need to explain the facts of the case. Please answer what you are asked. It's very important. Okay. So now I give you the sample. Please follow this format in answering question in part A. So it's your assignment. So find the case of Wang Chim-ying, general law, area of law. Follow the format of the case of Markov file. Specific issue. File the point of dispute. Okay. Argument. So for C and D. So argument of the appellant and also respondent. And then in D, you have to explain the reason of the judges. Okay. D, you just state the outcome. Okay. No need to explain the reason for the outcome in say in question in part E. This one. In item E. Okay. So you just state the outcome. No need to explain. You only have to explain on part D. Okay. So for part B, civil law and criminal law, they are different. They serve two different purposes. Okay. So of course, in your answer, don't just explain the two different purposes of criminal law and civil law. You also have to explain the differences between civil law and criminal law. So on the one hand, so the purpose, you may say that civil law is mainly for compensation, criminal law is mainly for punishment and deterrent. Of course, you have to elaborate. Your answer cannot be so simple. Okay. So your answer should be 600 words, and then you have to explain other differences. For example, the burden of proof, the standard of proof, procedure, evidence law, and also who is going to pay. In civil case, you have to pay all the legal costs, but in criminal case, you don't have to pay. If you are the victim, okay, all the money are paid by the government. And also investigation. So in civil case, you have to do the investigation by yourself. You don't have the authority. For example, you cannot go inside. You cannot enter into the defendant's home, or you cannot go to his office to search his office, to search his computer. But in criminal case, the police officer can do so. Also try to spot all more differences between civil law and criminal law. Okay, any more question for the assignment? Now we go to the last part of this lesson. So it's the revision notes. People that altogether we have 10 chapter in this module, chapter 1 to chapter 10. For the examination, so you only have to answer 3 out of 5 questions in section A and 1 out of 2 questions in section B. It means that altogether there will be 7 questions in the examination. Usually it's a closed book examination. So for legal system usually so I think the exception is this time. Okay? So in September this year we have an online examination. Okay? It may be I hope it may be one and the last one. It should be the one and last, the only one. I don't want any online examination in the future. Right? So I hope in the future all the examination will be just the same. We have a closed book examination, and also the examination is in the classroom. So of course, shortly before the examination, altogether we have 3 sittings every year. Usually we have 3 sittings: June, August, and also I think it should be November. So you can join any sitting. So shortly before the exam, so there will be a revision seminar. So you will be distributed a workbook on for revision workbooks or something like that. Okay. So in the workbook there will be past paper, also some sample question and answer, and also I think some advice or guideline for examination, something like that. Usually I will explain to you how to prepare for the examination. So I will go through the answer of those sample questions so that you can know how to answer the question. And also we have altogether we have 10 chapters. But please note that for chapter 1, chapter 2, chapter 1, chapter 2, and also chapter 4, usually there will be no question on these 3 chapters directly. Okay? So it means that you may ignore chapter 1, chapter 2, and also chapter 4. So you only have to focus on chapter 3 and also chapter 5, 6, 7, 8, 9, 10. So how many chapters remain if you exclude 3 chapters? So you only have 7 chapters remaining. So there are only remaining 7 chapters. So if you divide 7 by 7, we have 7 chapters, and then we have 7 questions in the exam. So what will happen? The answer is 1. 7 divided by 7, it will be 1. It means that basically, so each question usually is on different topic, different chapter. Okay? So usually 1 chapter will have 1 question. Okay? But do you have to answer all the 7 questions? The answer is no. You only have to answer 4 questions. Okay? No need to answer all the 7 questions. You only have to answer 4 questions. So these are the main points. Sources of Hong Kong law. So we have different sources. The basic law is supreme, and then we go to the legislation, national law of China, common law and equity, and also customary law. Please note that international law is not a source of law in Hong Kong. International treaty will not be applied directly to Hong Kong. Usually it will be converted into an ordinance. Okay. Only the ordinance will be used. The international treaty cannot be used directly in Hong Kong. Case 5. So chapter 5 is basically case law. You have to be very familiar with the doctrine or precedent, stare decisis. So we have 2 vertical stare decisis. Vertical is about the relationship of higher court, and also lower court. Okay? So the principle is very simple. Lower court is bound to follow the decision of the higher court. For horizontal, I don't think that the rule is the same for each level of court. For different level of court, they have different rule. CFA, okay? CFA usually will follow its own rule. It will be very exceptional if CFA does not follow. For CA, it will be bound by its earlier decision unless the earlier decision is plainly wrong. CFI and below, no need to follow. Okay. Also, when we say you have to follow a precedent, it only means that you have to follow the ratio decidendi. The ratio decidendi means the underlying principle of the case. There's some statement which is called obiter. Obiter dicta. They are principle of law, but they are not related to the decision of the case. They are called obiter dicta. Only ratio decidendi has to be followed. Right? For example, when you say you have to follow the case in CFA, it only means that you have to follow the ratio decidendi of that case. Law 6, legislation. So we have two parts. The first part is minor one, passing of legislation. Okay, usually, so not every year we will have a question on passing of legislation. So usually it's only a Section 8 question, and not every year you can find this question. But for statutory interpretation, you can really find this question every year. Every year there will be a question on statutory interpretation, either in Section A or Section B. Okay? So your job is to explain the different approach of the statutory interpretation. So we have the little rule, golden rule, mystery rule, and also purposive approach. Right? Little rule, you look at the literal meaning of the legislation. Golden rule is to avoid ridiculous result. Mystery rule is to cover the mischief not covered by common law. Also purposive. Purposive means to file the purpose of the legislation. So the next one is court system, court and tribunal court system. So you have to know the jurisdiction. Jurisdiction, we have two classifications. Either the first one is appellate and also original. Appellate means the jurisdiction to hear appeal. Original means the jurisdiction to hear the case. Also, it's divided into criminal jurisdiction and also civil jurisdiction. Some courts have both criminal and civil jurisdiction, like district court. From district court and above, all the court will have both criminal and civil jurisdiction. But for some lower court, like the small claim tribunal, they only have civil jurisdiction. For magistrate court, they only have criminal jurisdiction. Jury is also a very hot question. You can find the question on jury in nearly every year. So you have to know the nature of the jury system, who are eligible, who can enjoy, who can be exempted, and also criticism, and also proposal for reform. These are the 4 different aspects of the jury system which you have to be familiar with. Also, for say statutory interpretation, you have to cite cases. So it may be the only question in legal system you have to cite case. Some students are very afraid of citing cases. People, that is a must. It's a must for legal study. So you don't want to cite case. Usually you cannot perform well in the examination. So ADR is what we have learned. So in this lesson, altogether we have 6 formats of ADR, and also you have to know the difference between the individual ADR, mainly mediation and arbitration versus litigation. You have to know the advantage and also disadvantage. For arbitration, we have advantage and disadvantage, but for mediation, it's quite one-sided. So you can only find the advantage, you cannot find any disadvantage or mediation. Legal profession, so we have different aspects, different subtopics like admission, say category of legal work. So we have contentious, like those work relating to litigation, they're called contentious. And also we have non-contentious, like those work not related to litigation, like preparing document, will, agreement, etc. Right of audience, so we have a solicitor and also barrister. For solicitor, they have only limited right of audience. They can only attend the court hearing in district court. But for barrister, they're supposed to have unlimited right of audience. But because of the dispute between the two different branches, now we have the solicitor advocate. For those solicitors who want to have wide job audience in the High Court, he can apply to be a solicitor advocate. Of course, he must have substantial working experience in litigation. Fusion, you have to know the pros and cons of fusion of the legal profession. So fusion means that we have to merge so the branch of barrister and solicitor together. So in the future, there's those two separate branches of the legal profession. So professional misconduct. So for example, conflict of interest, etc. There are professional misconduct. So you know that for those people who are guilty of professional misconduct, they will be subject to this disciplinary action by the two different, professional body of the legal profession. Legal affair, rules, disciplinary proceeding, and also immunity. So we have the pros and cons for the immunity. For immunity, it means that the advocate mainly is the barrister. He can enjoy immunity from suit. Okay? Means that for the client, they are not able to sue the barrister if they think the barrister is negligent in conducting the case. So the last one is legal aid. So for legal aid, so we have the three different legal aid scheme. Okay, two of them are civil ordinary legal aid scheme and also supplementary legal aid scheme. Both of them are for civil cases. Legal aid in criminal cases is for criminal cases. For each scheme, you have to know the scope, okay, what they cover and what are the exceptions. For example, in ordinary legal aid scheme, it does not cover defamation case, it does not cover small claim tribunal, labor tribunal cases. These are the exceptions of this scheme. Two tests, so and also you have to know the two tests are M&M, means and merit tests. So for other than the three different legal aid scheme or the legal aid department, so we have the duty lawyer service. Duty lawyer service is collective term for so many services provided by them. So we have the major one is duty lawyer scheme. 當值律師計劃, okay? So it's a duty lawyer scheme. Some solicitor and barrister, they are on duty. They serve the purpose as duty lawyer. Of course, they will get some income from the duty lawyer service. Okay? So it's confined to legal representation in criminal cases in the Met Court. So in the Met Court, there will be no legal aid. All the assistance are by the duty lawyer scheme or the duty lawyer service. Other than the duty lawyer scheme, we have the free legal advice scheme. This one is only a 20 minutes consultation by a solicitor. Also, tell law usually is only provision of information. So you dial the telephone, you can listen to some recording, but no one will answer your question. Okay? It's only provision of information. Convention against torture, I think the name has changed. Sorry, but it's not something too serious. Okay? So that's all for legal system. Legal system, in fact, when compared with other model, this one is already the easiest one. So so this one is already the easiest one among all the 5 different modules in CLS. Usually most people will think obligation, module 3 should be the most difficult one. Laws of obligation, this should be the most difficult one. And also please be prepared that you have to memorize a lot of cases. Many students, they are very afraid of citing cases, memorizing cases. Sometimes they always ask the teacher, do I have to memorize the case? Can I choose not to memorize the case? Please note that is something unavoidable. So you want to perform well in legal study, please memorize the case name. It is something unavoidable. Any question? Any more question? Usually it's closed book. Online examination is open book, but quite difficult. Because we cannot give you some straightforward question. So sometimes open book exam may be even more difficult. Why? Because in if it's a closed book exam, we can give you some very easy question like explain the sources of law in Hong Kong. So if you can memorize all the information well, you can give a very good answer. Okay? Or say what are the criticism against the jury system? So usually the answer can be found in all the answer can be found in the workbook or the lecture notes. So for the purpose of examination, the PowerPoint is already enough. Okay, the workbook has a lot of information which cannot be used in the examination. I can tell you, so many parts will not be covered by the examination question. Okay, so if you just want to pass exam, have a good result, just focus on the just focus on the PowerPoint prepared by me. Online is quite difficult, and also you have to type. One of the difficulties is that you have to type the answer instead of writing the answer. Typing sometimes may be even difficult. I can tell you that. So usually for cases, we do not give. I think in legal system you will not find too many cases. I think only in the question on statutory interpretation you will have to memorize cases. But usually for each approach, we only give you 2 cases. Just memorize all the 2 cases. So Saturday night was Saturday. I think it's for assignment writing. Sorry, I don't know this class. Because I think it's conducted by another lecturer. It's not conducted by me. Yeah, very good. So I think Gwen. So just the cases mentioned in class. Usually it's quite enough. So I think for those cases mentioned in the lecture logs, usually they are quite enough for the purpose of examination. But of course, for doing assignment, you will need to do more research. Okay, so you have to read more reference book. But for examination, just memorizing, the main principle, usually is already enough. You will find that many students are very, they do not perform too well because sometimes they do not even know the general principle. A very basic principle, very general principle, and they simply cannot master. So it's the reason why they cannot perform well in the exam. Yeah, I think Saturday. I think it's only assignment writing. It will not be conducted by me. It will be conducted by another lecturer. So I hope I will see you. I don't know, because I will teach 2 classes on company law. I don't know whether it's your class or another intake. Right? So can you check your timetable? Is it January next year? I will teach company law in January next year. Is it your intake? I don't know. Because every year we have 3 intake. The September is called the main intake, and also in November we have the additional intake, and then we have a weekend mode. So altogether we have 3 intake, right? Oh, no. Are the examination content the same for each exam? Of course, it's no. The answer cannot be. Of course, we cannot give the same answer. There's regulation to prohibit us using the same question. Question sometimes they are. What I can say is that they are the same in substance, but of course they are very different in wording. If does someone have any problem, who can solve the problem? What's your question? Chen Harman, you may give me an email. Chen Harman, please send me an email if you have any question on doing the assignment. Oh, no. They are different. I don't think that they're the same. Learn came soon. So I think PowerPoint is quite sufficient for the purpose of examination. Usually it's quite sufficient. Even for good result. Not only a pass. You can memorize everything in the PowerPoint. You will not only get a pass. You should get a credit at least. So if you have any more questions, so please feel free to send me an email.
Mm-hmm.